Well, I'd like to join in welcoming you to this absolutely perfect setting for a discussion about privacy. It always makes me think when I'm in this building that Justice Brandeis suggested that sunlight is the best of disinfectants. And he was talking about shining light on things that we maybe don't talk about often enough and maybe need to do something about. So here we are in this great sort of open space. Hopefully we'll have some nice bright daylight throughout the day to talk about some of the issues that are involved in both government and businesses lurking in the shadows and perhaps threatening our privacy. Our first topic today is going to be on surveillance, and in particular the embedded technologies such as RFIDs, which stands for Radio Frequency Identification Devices, but Professor Smith is going to tell us a little bit more about what they are. Our panel members today come from many different places and have different kinds of perspectives. Our first speaker is going to be Professor Lars Smith, and he'll be presenting a paper about RFID and other embedded technologies. Who owns the data? Professor Smith is professor of law at the University of Louisville. Before that, he was with the Franklin Pierce Law Center and practiced law in Boston and New Hampshire. He's a graduate of Colby College and New England Law School and holds an LLM in intellectual property from Franklin Pierce. Our responding to him is going to be Sonia Katyal. Professor Katyal is at Fordham University, and she has clerked for Justice Carlos Moreno, who is currently on the California Supreme Court, as well as Judge Dorothy Nelson of the Ninth Circuit. She practiced law in Washington, D.C., and is a graduate of Brown University and the University of Chicago Law School. Just next to her is Nicole Ozer. She is the Civil Liberties and Technology Policy Director for the ACLU in Northern California. Like Professor Smith, Nicole is a recovering intellectual property litigator, although she was here in California with the very fine firm of Morrison and Forrester. She's worked with the Berkeley Law Center for Law and Technology and the Samuelson Clinic, and we'll probably hear some more about that as well. She's a graduate of Amherst College and has a JD from Bolthouse School of Law, for which we forgive her. She has also studied civil rights at the University of Cape Town in South Africa, and could have some very interesting things to say about that experience. These first three speakers are going to be talking mostly about RFID devices. And after Nicole responds to Professor Smith, we're going to take a few minutes for some questions from all of you, so keep your questions in mind. So we'll take, maybe about 10 minutes for questions before we turn to our speakers who will talk more generally about surveillance. The person to Ms. Ozer's left, your right, is Charles Pinck. He is a private investigator who works out of Washington, D.C., and investigates a whole variety of, these days, mostly civil matters on a worldwide basis. He is the Vice President of Investigations for GlobalOptions, Inc., which is a consortium of private investigators who do all kinds of very interesting work, some of which he's agreed to tell us a little about today. He's done some work with political campaigns, and he is a testifying expert on investigations in litigation. He was one of the early adopters of the Internet as a tool for doing private investigations, and something that I think is very interesting. He is the co-author of a book called Stalking the History of the Office of Strategic Services, and he's promised to say a little bit about what the OSS is and was. He is a Boston native, and he graduated from Washington and Lee University. Now, Scott McGrew is our anchor man, literally. He covers technology issues for NBC News, our local affiliate, Channel 11, and he's been a television reporter for more than a dozen years. He's been about 7 years here in San Jose, concentrating on technology. He produces and, in fact, created the wonderful technology show called Tech Now. If you have not seen Tech Now, you must see it, but my guess is that you are all already watchers of this television program which concentrates on technology and the effect of that technology on the communities that we live in. Scott McGrew graduated from Iowa State University, and he has a double major in political science and in English. So we have a stellar panel to be talking with today, and our first speaker is going to be Professor Lars Smith, who is going to explain to us what RFIDs are.
Good morning. Thank you for that kind introduction, Professor Glancy. I'd like to thank the Santa Clara University School of Law, Computer and High Technology Law Journal, and High Tech Law Institute for putting together this symposium and for inviting me to present on the topic of RFID and surveillance. I'd like to start out with reading a small excerpt from a recent book published by Catherine Albrecht and Liz McIntyre called Spy Chips. Imagine a world of no more privacy, where your every purchase is monitored and recorded in a database, and your every belonging is numbered, where someone many states away, or perhaps in another country, has a record of everything you have ever bought, of everything you have ever owned, of every item of clothing in your closet, every pair of shoes. What's more, these items can even be tracked remotely. Once your every possession is recorded in a database and can be tracked, you can also be tracked and monitored remotely through the things you wear, carry, and interact with every day. This book presents a somewhat frightening view of what the future may bring, a future many of us want to avoid. While there may be issues about whether the book presents accurately, a completely accurate view of our likely future, the concern about who has control over that tracking data is real. For example, most cars manufactured today contain dozens of computer systems tracking things like speed, oil pressure, and emissions. That data is stored in your car, available for later download by your dealer or your insurance company. Chase Bank is now offering a contactless credit card called PayPass that allows you to purchase goods merely by waving your card at a reader. Cell phones are used for the same purpose elsewhere in the world. Now, there are two main views about control over personal private information collected and compiled about individuals. First is the privacy law view. Who has the right to use the information? The discussion focuses on the legal protections against the use of our personal histories by companies and governments. In fact, in the U.S., we provide only limited protection for private personal information. While the law may limit access to some extent to your health information, telephone conversations, and video rentals, there's no single comprehensive system that protects all of your private personal information in the U.S. You may have the right to bring a legal claim for publication of private facts, but even that is circumscribed. A discussion about the privacy law view generally focuses on what the law should be, not what it is. Second is the property law view. Who owns the information? As a real property, intellectual property professor, this is the question that I find interesting and the one I will focus on. The quick answer is, not you. In fact, to the extent that a company compiles data on your activities, such as your purchases, what online ads you respond to, or what brand of ice cream you eat, under U.S. law, it is likely that the party compiling the information owns it. Now comes the development of radio frequency identification, and with it the ability for companies and governments to automatically generate databases on individuals, compile that data, and use it to sell you something or worse. The question I have is, who has a right to that information? Do you, the owner of the car, owner of the data tracked on that car? Well, let's start out with the definition of what is radio frequency identification. Simply stated, radio frequency identification is an automatic identification method that uses transmitters, referred to as tags, that transmit a unique identifier via radio signals to devices called readers that pick up the signal. While RFID has received the most press in the last few years, it is actually a technology that goes back over 50 years, to World War II and the development of ID friend or foe technologies used to prevent the accidental shooting down of friendly aircraft. In its modern form, it is currently promoted as a system that allows for tracking of individual items throughout the product supply chain, from manufacturer to retailer, and finally into the hands of consumers. The benefits, if it works, could be considerable to retailers. In a recent study, Walmart, a significant proponent of the technology, found that the use of RFID reduced out of stocks by as much as 16%. And for a volume seller like Walmart, that is an enormous benefit. The two primary parts of the system are the RFID tags and the readers. The tags themselves can be tiny. Some companies sell tags that are no larger than a grain of sand. In fact, I have in my hand here a vial of Hitachi Mew chips, which, when you come up and look at them later, you will see are virtually invisible. They look like specks of sand. The tag has two parts. It has a chip and an antenna. The chip is programmed with an individual tracking number that is 96 bits in length, which allows for the tracking of everything manufactured by man for years to come. In fact, the number that I've seen thrown around is that it can track 80 trillion items. Obviously, for the system to be useful, standards for its implementation need to be set that can be relied upon by the individual participants in the distribution system. The current standard that appears to be taking hold is one set by a company called EPC Global, a nonprofit corporation that is the outgrowth of the auto identification system started at MIT, Massachusetts Institute of Technology. EPC Global has established a standard for the identification code referred to as the EPC. You can think of the EPC as the natural progression of the UPC, Universal Product Code, which is the ubiquitous packaging barcode that we are all used to. Where the UPC allows for the labeling of products by category, the EPC permits the labeling of each individual item in every category of every product produced, meaning each individual can of Coca-Cola on a shelf has its own identification, if it's tagged. The EPC has two major parts. There's the part that's set by EPC Global, which refers to the manufacturer, and then the manufacturer or retailer can set the product code and the individual serial number for the item. The tag communicates with a reader by transmitting over radio frequencies, and it is turned on when the tag comes into close proximity to a reader. Because it transmits over radio frequencies, there's a great advantage. It can transmit for as much as 30 feet, at least in the current form, and transmit through solid matter, although tinfoil will block it. So the fellows running around with the tinfoil hats actually got it right. In this way, it has a great advantage over barcodes because it does not require line of sight. Since it can be read from a distance and through solid matter, the reader does not have to be right next to the item. The tags themselves come in two major types, passive and active. A passive tag is one that does not have a power source and is only activated by a reader when it sends out a radio signal. That turns it on, and it in turn transmits the EPC, that individual product code, back to the reader. Because these passive tags lack a power source, they are primarily used only for identification purposes. At best, what they will do is transmit the data, the EPC, and perhaps some limited amount of information that has been programmed on it. Typically, they are write-once tags, so that they can only be updated once. And once set, they are forever set. Active tags, however, have a power source, a battery, which allows them to do much more. The future of this technology, it is considered that we will have the ability to install sensors with these tags so that they will actually be able to actively track information as they are being used. And in fact, there is a tag being marketed right now that claims to have as many transistors on it as the 8086 computer. It's manufactured by a company called Pinck, and it's called the Zuma chip. Of course, this leads to the next question: is when will somebody install Linux on it and run Doom? EPC has set up 5 classifications. Class 1 is the passive tags that are only write once. There are classes 2 through 5 that embody most of the active tags and the ability to track information. And it's mainly these tags that I think pose the greatest risk for privacy concerns in terms of the tags themselves, because they have the ability to actually store data and then retransmit it at a later date. Of course, this technology is not limited to the EPC system set up by EPC Global. Right now, your cars have many dozens of computers built into them, and they track data. And at some point, this will be transmitted by radio frequency to the government and the vehicle information infrastructure system, to your dealer, so that they can make repairs to your car. In fact, it is this question that I found interesting. What happens when you take your Chrysler into AutoZone? And AutoZone says, I can't fix your car because I don't have the ability to get the information about how it's running off of it. And it's this question that leads me to ask, this problem leads me to ask the question, who actually owns the information? And what kind of data are we talking about? There's 2 parts. There's the EPC, the product code itself, and the data that any sensors that are attached to the tag may track. So what kind of ownership rights might there be? For purposes of the discussion, I'm going to simplify it. There's going to be a merchant, a consumer, and a competitor. It's a gross oversimplification of the system, but I think for purposes of looking at the legal issues, it simplifies it. The merchant is the person who installs the tag. The consumer is the person who buys the product with the tag attached. And the competitor is the party that is seeking to access the data. In law, we consider the right to exclude others as probably the most important incident of ownership. So to the extent that the law allows the merchant to exclude others from access to the data, I think we can say at some level they own that data. I see 3 ways we can approach this. First, through the ownership of the hardware. Second, ownership of the data directly. And then, for lack of a better term, virtual property. I'm not sure if I'm completely happy with that term yet, but control, a form of ownership by control, both legal and technological. So who owns the tag? When you go to buy a product in the U.S., that sale is subject to regulation under the Uniform Commercial Code, Article 2, Sale of Goods. Although this is a state law system, it has been adopted by every state in the U.S. and so provides a fairly uniform system of analysis. The sale of goods occurs when title has been transferred to the product being sold. So when the consumer purchases a car, the sale is complete when the title to the car has transferred. But what has the consumer obtained title to? In other words, is it possible for the merchant to have retained title to some part of that car? Specifically, in this case, the tag and the other embedded technologies that track data. It's not likely. Under Article 2, it says that when a seller attempts to retain an interest in an article sold, at best what they get is called a security interest and not actual title to the thing retained. So therefore, when Chrysler sells you the car, you own the black box that sits under the seat that the state trooper looks at to tell you that, in fact, you were the person speeding. It came up in a similar case where somebody purchased a car and title to the tires was owned by somebody else. And the court came back and said, when you buy a car, tires are an intrinsic part of that, and so therefore it is assumed by the consumer that they're purchasing, when they purchase the car, they're buying the tires, and so therefore it's not possible to assert an interest in the tires. Perhaps the merchant could claim that the transfer was a bailment. Bailment is defined as the rightful possession of goods by one who is not the owner, with the obligation to return the exact item. Given that the merchant does not intend to get the tag back, It's not technologically necessary, and in fact defeats the purpose of it. They want the tags to be on your products forever. No bailment would exist here, and so therefore, because it is not likely that there's an obligation to return the tag. So a theory of claiming retained ownership and a bailment of the tag wouldn't work. Perhaps we could argue it's a lease, a sale of the car and a lease of the chip. A lease is defined as a right to possession and use of the goods over a period of time. And again, since the manufacturer isn't likely to ask for the tag back, it's not, I don't think that an argument that you have a sale and a lease of the tag. Now, I will say, historically, this is probably not true anymore, but it used to be when we purchased cars, we bought cars and had the cell phones installed and perhaps leased that technology. So it's not out of the realm of possibility. And I do think that through contract law, we can probably contract around a lot of this. But as a default system, I think it's pretty clear that the consumer would own the technology itself. Well, who owns the data? A different legal issue. I approach this from three perspectives: copyright law, trade secret law, and misappropriation law. Under copyright law protects original works of authorship fixed in a tangible medium of expression. The most important limitations for radio frequency ID tag data tracking is that, first, individual facts cannot be protected under copyright law. So to the extent that a competitor is downloading information off of a tag, but discrete pieces of information from that tag, since it's a fact, likely there's no copyright infringement. An example of that would be the electronic product code itself. Who owns that? There was a recent Third Circuit opinion, Third Circuit Court of Appeals opinion that said, in the case of product codes developed by a manufacturer, a competitor had published the codes in their catalog and said, our products are substitutes for these product codes. And the court came back and said, you can't own the individual product code. They said, first of all, since the code itself is developed by a set system developed by the manufacturer, it's automatic. There's no original expression. And on top of that, copyright law does not protect short phrases and words. I'm pretty confident that the opinion would be upheld on appeal to the Supreme Court, since it was written by the soon-to-be confirmed Judge Alito. Of course, the merchant could argue that the data consists of a compilation, which itself is separately copyrightable, which is true, and the courts have been willing to accept that compilations of otherwise uncopyrightable facts themselves can be subject to copyright. But there has to be some original expression contained in that data. And through a series of cases comparing whether the automatically created databases, most courts have said if the information that is stored and tracked is just automatically generated by a system, there's no original expression. Compare that to the Red Book, which sets values for used cars. Since there is at least some originality going into deciding what a car is worth, the database of values of cars themselves can be protected. Finally, as a matter, I see I have just a couple of minutes left. Who's the author of that data? The tag is on your product. You, the consumer, are creating the data as you walk through the world and do things. The tag is writing data based on what you've done. So therefore, it's not likely that the merchant can claim that they're even the author of that data. And so perhaps the consumer would be the author, to the extent that any authorship exists. I'll finish off with discussing trade secret law, because I don't think misappropriation law works very well. Information is protected under trade secret law if it derives independent economic value from not being generally known and is subject to reasonable efforts to maintain its secrecy. So the first question is it secret? Well, to the extent that a tag broadcasts everything that's on it, no. But the EPC Global has built into their protocol a system for encrypting data on tags and also encrypting the transmission and password protecting the information. So a merchant could at least make the argument that they have taken reasonable steps to protect it. But it's sort of an odd situation. They would be claiming trade secret ownership of information in data that they don't control and don't even generate. So, short of a contractual agreement by the consumer that in fact the information is secret and they will keep it secret, and that the ownership is in the merchant, it's not likely that courts would approve an argument that says the merchant owns the information on the tag because it's their secret, not the consumer's. Finally, there are some other theories, again, misappropriation, and then also a common law theory set out by Judge Kaczynski in the Kalita Airways case. I explore that some more in my paper, but I look forward to questions from the audience. Thank you.
Professor Katyal, you have some views about RFIDs as well.
Thanks, Lars, for a very masterful presentation of the various complicated facets of the RFID controversy. To some extent, RFID controversies raise a myriad of different sets of issues, which largely, I think, converge on two separate themes, both of which Lars has identified. One involves property, as Lars has done a wonderful job discussing, and the other surrounds the question of privacy. And I think in order to really understand sort of the nature of this conflict, it might be useful to take some of Smith's comments and situate them within a framework that is well known to many privacy scholars, and that is the framework of the panopticon. The panopticon was a type of building that was designed by the philosopher Jeremy Bentham. And what it consisted of was a series of cells that circled a central tower. And the idea of these cells and their relationship to the central tower was that the central tower essentially suggested but did not confirm the presence of a central observer. So you could never tell for sure whether or not you were being observed at a particular time. And today, I would submit that the very same principle is actually operative in Smith's paper. The difference is that the panopticon is not just one building, right, and a series of cells, but many buildings. And the cells are not just single rooms, but they consist of products and properties that we may rely upon and utilize in our everyday activities. And so I would suggest that we've moved into a framework of panoptic properties, properties that collect information, just as they also affect the privacy and the autonomy by individuals through the mere suggestion rather than confirmation of surveillance. And as many privacy scholars have argued, this suggestion of surveillance carries important productive effects in terms of inducing individuals to conform to a desired norm. Now, much of this turns on the question of whether or not the profiling is anonymous, and to a related extent, whether the content of the information itself, consumer taste, products, and so on, are those that we would prefer to keep private. But Dan Soloff, who will speak later today, privacy guru, has suggested, and I think quite perceptively in his work, the existence of a related harm. And that is the harm of not knowing precisely what records are being kept, and also the problem of inaccessibility, suggesting that the specter of bureaucratic control over our information is something that we have no power to control and affect. And this factor, I think, limits our ability to control our personal information, which I think in turn affects our degree of participation in society. Now again, these panoptic properties raise clear privacy issues, and our next speaker will be focusing on some of the specific issues that relate to statutory and constitutional protections. So I actually want to focus more generally on some of the autonomy issues that are raised by RFID. Now, we might think of RFID as something that is sort of invisible to us, right? Very small little tags. But the danger exists that RFID receivers could be strategically placed to read the contents of the things that we carry. So some RFID readers can read more than one tag, as Smith points out, enabling receivers to read the data from several different items a person may be carrying, and to construct a consumer profile in that manner. Now, I think that this clearly might affect our right to purchase and use products with a general assumption of anonymity, which is something that I think many of us implicitly expect in the marketplace, but I think that the reality, as we're seeing, is actually quite different. So it leads us into a world of not just panopticism in terms of surveillance and behavioral control, but panopticism for the purposes of profit and marketing. It leads to direct surveillance by vendors, indirect surveillance by third parties. But as Smith correctly identifies, there's actually quite a hidden irony here, right? These panoptic entities also constitute items of personal property, as Smith points out, that the consumer may somewhat ironically own as a tangible entity. But RFID technology can also be used, sort of somewhat ironically, to actually generate further owned property for the originating company, for the vendor. So there are two levels of property rights that are operating here. One level is tangible and one level is intangible. And this, ironically, I think, leads us back to the fundamental conflict that RFIDs raise between privacy and property. But here, of course, we have a uniquely sort of interesting layer of conflict where the tangible chip might be actually owned by the consumer, but the data itself, ownership of the data, is unclear, as Smith points out. And ironically, the data itself is not protected by copyright due to a lack of originality under basic principles of copyright law, under the Feist case that Smith correctly identifies in his paper. Now, all of these raise so many sort of complicated questions, but I think that they converge on a further question, which is whether or not the question of privacy itself should rightfully be solved with the use of a property paradigm. Put another way, is consumer privacy potentially a property right enjoyed by the consumer? Should we think of our consumer data through giving consumers exclusive commercial property rights over their information? Now, certainly this allows the consumer to control their information, but it also raises the question about whether more property rights is always the answer. I personally sort of admit to being agnostic on this question, largely because I look forward to hearing how statutory common law developments can solve some of these questions. I think that the question about whether privacy is a property right raises significant market complexities that would make it difficult for consumers to sort of be fully informed about their decisions about how their data will be used. And I also think that there are some moral complexities involved in equating the basic and fundamental right of privacy as a potentially tradable good. But furthermore, I also believe that a combination of litigation and legislation may provide us with some guidance in governing private data collection. And I also think that these means can help us restore this critical balance between privacy and property. And so I look forward to hearing how the ACLU has sort of dealt with some of these questions. Now here, I think what I'm focusing on are a couple different ideas. The idea of notice, right? Making the method of collection more transparent to the consumer. The idea of consent, ensuring that the consumer knowingly consents to the collection of data. The idea of control, that the consumer has some degree of governance over how the data will be used. And finally, but of course not exclusively, the idea of anonymity. The idea that the data will be separated from an individual person. But I also think that given these issues, the sort of critical, larger debate that exists between privacy and property is actually quite endemic, I think, to our existence in both real space and cyberspace. And so the RFID controversy is just one of many controversies. But I think particularly I want to commend Professor Smith in sort of doing a really wonderful job identifying the salient issues for RFID and beyond, particularly in terms of this relationship between tangible and intangible properties that I think will increasingly become more and more complex. Thank you.
We are now pleased to have Nicole Ozer from the American Civil Liberties Union to talk about some other angles on these RFID issues.
Thanks very much, Dorothy. I want to thank Professor Smith for developing such a thought-provoking piece. And my central response today really relates to the scope of the article. In his introduction, Professor Smith writes that the privacy issues related to RFID and the tracking of personal information by companies and the government are interesting, but that the article will instead focus on the issues of ownership of the information contained on the chip. My core response today is that the privacy issues cannot possibly be a separate inquiry. The privacy issues are absolutely fundamental to an analysis of who owns the data, and those privacy issues must be considered along with any property analysis. From the moment that an RFID tag is associated with us, either because it's attached to a consumer product or embedded in our identification documents, the data becomes about us, our habits, who we are, our identity. And when our personal information comes into play, it becomes our data. Whether it's in the commercial context, whether it's in the government context, we have a right to privacy, a right to control our data, how it's used, how it's accessed, how it's collected. And anything else conflicts with our personal right to privacy. So my central response to Professor Smith's paper is that federal and state constitutional protections, as well as legislation, is fundamental to an analysis of who owns the data. And I'm going to briefly discuss some of those constitutional and legislative protections, both in the consumer context and in the identification document context. First, our right to privacy, as people know, is included in the Constitution, and particularly here in California, it's explicit in our California Constitution. Article 1, Section 1 of the California Constitution, lovingly called the Privacy Amendment, was overwhelmingly approved by California voters in 1972, specifically to guard against the expansion of government surveillance and data collection. In White versus Davis, the first California Supreme Court decision to interpret the Privacy Amendment, the court noted, quote, "The moving force behind the new constitutional provision was a more focused privacy concern relating to the accelerating encroachment on personal freedom and security caused by increased surveillance and data collection activity in contemporary society. The new provision's primary purpose is to afford individuals some measure of protection against this modern threat to personal privacy." For RFID in the commercial context, civil liberties organizations from around the country and around the world came together in 2003 to develop fair information guidelines to bring RFID use in the commercial context into line with privacy rights. And Professor Katyal exactly mirrored those comments that the civil liberties organizations had developed. Openness and transparency, knowing when products or items have RFID tags, that there shouldn't be surreptitious tag reading, that RFID tags and readers should be clearly labeled, and that we should understand the specifications, as well as number 2, purpose specification, that we need to know what the tags and readers are being used for. 3rd, collection limitation, that we should know and the collection of information should be limited to that which is necessary. And security safeguards, so that our information is protected from third-party reading. Since 2003, when those protections, when those recommendations were put forward, the RFID industry talked a lot about self-regulation and the need for not having legislation, but nothing has happened since 2003. But there have been several bills that were put forward in many states, California, Massachusetts, to put in very basic rules in terms of notice, knowledge about what the tags are used for. And actually just yesterday, very timely, the New Hampshire House of Representatives passed an RFID bill that would do just that, to provide notice to consumers. It was an amendment to the state's Consumer Protection Act for all consumer goods that were embedded with RFIDs to have a universal symbol to let people know this. That bill is moved through the House of Representatives in Rhode Island and is up for a vote in the second house. So that's very exciting. In the government context, RFID is even more troubling still because it's about RFID tags being embedded in those documents we all carry every day that have personal information about us, whether it be our name, our address, other personal information. But But in the identification document context, we have both constitutional protections as well as scores of legislative precedent that the data belongs to us. I'm going to go briefly through these as well. In federal legislation, the Driver's Privacy Protection Act, which was enacted in 1994, protects the privacy of personal information assembled by the Department of Motor Vehicles. It prohibits the release or use of this personal information by the DMV, penalties if this information is shared, and requires states to get permission from individuals before that information can be sold or released to a third party. Federal legislation as precedent that this information belongs to us and requires our authorization to be released. This past semester, I've been working with the Stanford Clinic. We've been analyzing driver's license privacy laws in the 50 states, which is an arduous task, and we are almost done with it. So that we'll have chart and a white paper released in the next couple months looking at driver's license privacy laws. So there's several, from that research, we found several areas of legislative precedent that we retain control over our data. Legislation in many states has ensured that the data stays within our control, controlling what digital information is included on driver's licenses, who is able to access that information, and how the digital data is collected or recorded by the few that do have access to it. There are controls on what information is included. A large number of states, everyone from Alaska to Colorado to Kentucky, prohibits the inclusion of social security numbers on driver's licenses, understanding that we have a privacy right in keeping that information confidential. Second area of law is that we don't have to show our data to everyone. Almost every state has a law on their books that requires us to show our driver's license to a police officer. Why do they need to have that kind of law? Because there's an understanding that we have a right to privacy, that we have a right to keep our information private unless there is an affirmative law requiring us to show it to others. The third area, laws protecting our digital information. Several states around the country have laws controlling who can use electronic means to read digital information on our driver's license that's held on the magnetic strip on the back of the license. Also, for what purposes it can be read and what they can do with the data once it's read. California. Our California Civil Code has a law that controls when a business can swipe a license and what they can do with the information. They can only swipe a license to verify age or to satisfy another legal requirement, and a business may not retain or use that information for any other purpose. Connecticut, very similar law as well, that employees cannot electronically or mechanically record information derived from a transaction scan except for those similar purposes. Rhode Island also limits what access entities can have to the digitized information, solely determine the age or individual for a transaction or right of privilege dependent upon age, and prohibits the storage, recording, or retaining of that data. And even our friends in Texas understand that we have a privacy right over this information. A person commits an offense if they access, use, compile, or maintain a database of electronically readable information derived from a driver's license unless for authorized purposes. So there is a slew of legislative precedent that we own the data, that we have a privacy right in that data, and that we are the ones that own it. Not only is there legislative precedent, but currently there are many attempts to update the laws to ensure that those rights to privacy are maintained as technology is updated. In the possible event that our magnetic strip becomes an RFID tag, there are several states that are updating their laws to ensure that it isn't just based on a magnetic strip, but also on anything that can be electronically read. SB 433 here in the state of California update the no swiping the magnetic strip law to include no reading of electronic information if it were an RFID tag as well. And Washington State is also looking at a similar bill and developing a task force about that issue. As well as one of my favorite topics to talk about, RFID bills with identification documents, SB 768 here in the state of California, putting in privacy and security protections on the use of RFID tags in identification documents, limiting the amount of information on those RFID tags to only a unique identifier number, putting in encryption and authentication, and making it a misdemeanor to skim information off an RFID tag without authorization. That bill is moving through the California legislature with broad bipartisan support and has been used as a model for several other states that introduced similar legislation this year. So from the East Coast to the Midwest to the West Coast, there is definitely a move both in the consumer and in the identification document context to ensure that privacy is protected and the privacy and security that we currently enjoy over the information that we own will be maintained. Thanks very much.
There's now time for you to raise questions. If there are questions from the audience, we have a little time to talk about RFID issues, and if you would come to the microphones in front, it'll make it easier for us to hear you and for everyone to hear you. So are there questions? How about questions from the panel?
I have a... okay. I have a question for you, Nicole. In fact, I think that's absolutely right. There are a lot of attempts to protect individual privacy. Doesn't it suggest, however, in reverse, that since those laws are deemed necessary, that in fact there is no underlying principle that we own the information, and it's not until a legislature acts to protect it that it's protected? So therefore, to say that it's our property is actually, I would suggest, disproven by the fact that these laws are necessary. We don't have a default right in the information, and it's not until some steps are taken to protect it that we could make that claim.
I think we see two sorts of areas. We see how we have an initial privacy right in having having control over the information and over our driver's licenses, like we see the laws that have to be put on the books for us to hand over our driver's license. So I think we have an initial right to that privacy. I think there's two reasons. Well, there's a major reason why we put in the law, and that is it's much easier to have an affirmative law than to necessarily litigate based on a constitutional principle. And so the legislation, I would argue, is a safeguard to ensure that there's no confusion rather than evidence that the privacy right doesn't exist.
Are there further responses from the panel? Yes, Professor Cho.
My question is similar to Lars's. I mean, I think it's a big leap from statutes protecting disclosure of information on driver's licenses to say that there's ownership of personal information in the consumer. I mean, I think it's quite clear, for example, under basic copyright law, that facts about you, such as your address and your phone number, are facts that are not owned by anybody. They're in the public domain. If somebody, if somebody knows where you live and chooses to maintain that information on some kind of database, absent a statute, a privacy statute, you don't have any control over where that goes. The driver's licenses is an example of the government owning a database that is restricting itself. It's restricting its own disclosure of that database. But I guarantee you, that statute could be wiped off the books tomorrow, and they could disclose that information to anybody they wanted to. So, I mean, to say that there's a default principle of that consumers own their own data, I think, is not at all supported by this evidence.
I think several of you would like to respond. Would you like to start?
if you wouldn't, I'm going to actually add to that, and because I'm really interested in Nicole's perspective. It seems to me that whenever there are issues like this that are raised, one of the key issues is, I think, sort of an invasive tendency among sort of marketing companies to think of this as their property, right? Their data. And I think that one of the sort of fundamentally clear responses, sort of on the other side, is to then kind of ramp up the property right in response, right? The property right of the consumer. And I personally think that this question about property versus property, I mean, it's really conceptually interesting from a theoretical perspective, but I also think that it does tend to kind of overlook the sort of the other regulatory ways that we can deal with the problem. And so I guess I'm sort of interested in hearing from Nicole's perspective whether, I mean, it's thought of as one or the other, sort of increasing property, increasing regulation, or if there's a certain preference among privacy activists for one or the other.
I think that we have to look at the situation that's happening as well as the resources that you have available in a state for how you deal with the issue. Here in California, we have a very strong constitutional right to privacy, as I discussed. So we're able to tackle issues through litigation and through constitutional protections that might not be possible in other states where it really has to be through legislation in order to address it, or just through public response to an issue. But I think that there is the same reaction we get from people about their driver's license. It's very different having information that's on your person, either in an identification document or attached to a consumer product that you own, and that information being obtained surreptitiously, or just being coerced or being forced to give over that information. You know that your address is on Zaba Search. But when you go into a store and someone says to you, you must give me your address or else you can't purchase this product, those are very different things. And so there's the line in terms of having protection over personal information that you're carrying, that you're being asked to give over, and protection over personal information. So, I would respond to you in that way.
Are there further questions from the audience? And yes, Scott.
It's a question for Professor Smith from the non-lawyer on the. You set up a hypothetical that it was a consumer and a vendor and a competitor. I assume the hypothetical is then that the competitor would want to access the data for his or her own use for some sort of benefit. Would your argument or the law change at all? The arguments in the law change if the competitor or even the consumer meant to change the data or even destroy it?
Yes, I mean, and I explore this more in the paper, didn't have enough time to go into it. It's a very interesting question. If you own the tag, you have the right to get rid of it, right? It's your tag.
Or could somebody sell me something that destroys it or scrambles it?
Sure, right? I mean, I think that's the starting point. If you own the hardware, you should be able to do whatever you want with it, right? You buy a DVD. You don't own the content on the DVD, but you have a right to throw out the DVD if you want. So they're absolutely. And to take it a step further, if you own the hardware, shouldn't you be able to allow other people to have access to it?
Right.
So, I mean, obviously, decrypting a DVD, no, you would not be allowed to do that yourself or anybody else. But if the information contained in the tag is not protected in any way, it's not property, why shouldn't you have the right to let AutoZone tap into your Chrysler and fix your car, even if Chrysler doesn't want that to happen?
Okay.
Well, it's the same as what we are seeing in the DVD context in terms of the DMCA and other technological protection measures being used in anti-competitive ways, even though there is no actual underlying copyright ownership or any other ownership of the information.
Ms. Poe? You need a microphone.
Really?
Yeah.
When you were talking about this hypothetical, one of the things that occurred to me was, I'm sorry, Professor Glancy, I completely overlooked the property issues, is the antitrust issues when you're dealing with a competitor. I mean, do you think that that would be a way to get at some of these issues by approaching it from the commerce side as opposed to the personal property side?
It's a fair question. I have not explored the antitrust considerations in this area. My first reaction would be there shouldn't be an antitrust problem in you not allowing other people to get at information you own, right? That would be the merchant's point of view. It's my data. I don't have to give it to you if I don't want to, right? Now, of course, there are some limits to that. But no, I have not explored the antitrust problem. That's, I guess, the third article that comes out of this. And somebody, I'd love to hear if anybody has an opinion about what the antitrust considerations would be.
Well, I think we're going to turn our focus slightly, sort of more broadly, to surveillance in general. And we have as our first speaker on the more general topic, Charles Pinck. You're a private investigator. Your job is invading our privacy, right?
It's debatable.
You're also promising to explain to us the OSS?
I will do that, yeah. Sure. Good morning, and thank you for inviting me to this conference. I can't imagine a more timely event given the headlines that are going on. Not too long ago, I was called for jury duty in Washington, D.C., where I live, and I was pulled into a potential jury pool, and we were pulled into the courtroom, and they started doing voir dire, you know, where they ask you all the questions about yourself that they ask you. And it was my turn, and they said, one of the attorneys said, well, what do you do for a living? And I said, well, I'm a private investigator. And the judge interrupted him. He had his reading glasses on. He looked over at me and goes, and you do this for a living? And I didn't know what to say. I said, yes, you know. But it is what I do for a living. I've been doing it for almost 15 years. And I think investigators are sort of an important part of our legal system. And really the work we do, I think there's some sort of popular misperceptions about it, largely due to the TV shows that come on and disappear quickly, like Snoops and Eyes, and you know, they have PIs doing all kinds of illegal things. And in my experience, that's simply not the case. Primarily because, you know, our clients, at least my clients, who are involved in high-stakes litigation, the last thing they want me to do is to get them in trouble or their client in trouble. So I think it's important that we all realize that PIs work within the framework of the law, by and large, and we do important work gathering admissible evidence. I mean, you can't go out as a private investigator in a big case and gather evidence that's going to come back to hurt you and your client. So I think that's an important point to make. You mentioned the DPPA, which has actually proved quite effective in limiting access to driver's records. Let me make this point too. My career in this business sort of began when much of this new technology was just coming online, including the internet and much of the surveillance technology. And I might also add, since this is a conference about surveillance, I hate doing surveillance. Most PIs really detest doing surveillance. It's long hours, you're sitting, you're watching someone, they don't do anything, it's incredibly expensive, number two. And then when they do something, you're in a panic because you're following them and you lose them, they do something, you can't get on a plane. I mean, it's sort of like 10 hours of sheer boredom followed by 20 minutes of sheer terror. And you talk to PIs, they don't like to do surveillance. This is an important point to remember. I've also made a point, and you'll see in one of the articles that I think is included in the program, you know, at various times, and last year's a good example, there was a big breach with ChoicePoint, as I'm sure many of you know, and I think there was data stolen from ChoicePoint on 160 or 180,000 consumers. In fact, today I heard that they're, I think, paying a $15 million settlement. Is that right? Of course, the first people they blamed were the PIs and immediately cut off access to their information. In fact, investigators weren't to blame in that case. It was actually ChoicePoint themselves that, as I understand it, failed to properly vet their clients and find out who they were. And that's what resulted in the theft of that information. There are many beneficial uses to this information. I've also written a little bit about that in response to the breach last year, and I think it's important to remember how this information, much of it public, can be used in a useful way, because I think we often overlook that. And I'll just give you a few examples. We had a case not too long ago where an executive of a company embezzled about $3 million from his company. And basically the way he did it is he forced a vendor to overcharge his own firm and then give him the difference. He pled guilty to this, but claimed to the assistant DA negotiating the plea agreement that he had no more money left. Our client obviously didn't believe him, so we followed him and suspected, I might add, that he'd taken some of this money offshore. So we followed him, and again, just got on a plane with him, followed him down to one of the Caribbean islands. And I'll never forget, I walked into this island not really knowing what to expect in terms of public records or public access to data. And there was a little shack, and I walked in, and they had all their property records online, and I handed the name to this clerk, and he came back and said, yeah, he owns 3 condos, he owns a car rental agency, he owned a restaurant that burned down under very mysterious circumstances, and I found the insurance agent who hated this guy and gave me copies of the checks he'd given him. Another case also involving surveillance. We had a client who believed herself to be the illegitimate heir of one of the country's wealthiest industrialists. He's deceased, his children are still alive, but in order to prove this, our assignment was to try to get a DNA sample from one of his children and then compare it to hers. Not an easy task, I can assure you. These are people, they're very wealthy, they're not going to McDonald's. We also had to prove chain of custody, that's the other thing. In other words, the investigator who actually obtained the sample had to be able to testify in court that I saw, Susan or James use that fork or smoke that cigarette or whatever. So that's another example where surveillance played an important role in our case. One more case I'll just mention too. We had a client, a Fortune 50 corporation that had an agreement with a firm, and they believed that this firm was secretly giving this technology to a competitor. And in fact they were. We had them under surveillance. We found a secret facility that they'd established, and they were moving a particular, it was completely out of like a James Bond movie. They'd show up at night in this black truck with no lettering on it, and they'd move this thing out and move it back and move it back and forth. That's typical of surveillance work. The change as I see it is you now have, surveillance has always been I'm watching someone, I'm following someone. The difference now with much of the technology is you're seeing the possibility of doing what I would call remote surveillance. And I don't think the threat so much, the threat as I see it is the ready availability of this information. You can find this stuff on the internet, anybody can buy it. You can get GPS tracking devices that even though they're illegal to use on a car unless you own the car or you have the permission of the owner of the car, I find it hard to believe that there aren't people out there buying this stuff and using it, and frankly if someone has one on your car you probably would never know about it. So that's what I see as the threat in terms of the emerging technologies. And this stuff does manage to leak out. Recently there's been a lot of media attention over the sale of cell phone records, again, over the internet. And that's information that I all think we expect, to remain private, that anybody can go onto a website and buy. So I think what you're seeing, whatever new technology develops, somehow it is a way of leaking out, overtly, covertly. As long as they're human beings who control it, or control any information, I think you'll see that this will be a continuing problem. But essentially what we do, and I'm straying a little far afield off the question of surveillance, is really gather facts that can be used as admissible evidence, and I do think it's an important component. My firm does a lot in the asbestos litigation field, and I'm sure you're familiar, a lot of companies have been overwhelmed by it. And many times what we find is someone sues a particular company for asbestos exposure, and they're ill, and that's tragic, no doubt. But the question then becomes for us, where were they exposed to asbestos? Oftentimes they'll want to sue those with the deepest pockets, and our task in those instances is to really investigate someone's background. Were they in the military? Were they doing homework? There was so much asbestos around 40, 50 years ago, it was almost hard not to be exposed to it in some manifestation or another. And in many of those investigations, we do find that the exposure occurred in places other than where it's alleged to have occurred. So I think that's all I want to say about that. Dorothy asked me to say a bit about the OSS Society. I'm sure as some of you are aware, the OSS was the wartime predecessor to CIA. Not many people are aware that it's also the predecessor to the U.S. Special Forces. There were groups within OSS called the Jedburghs, and these were these kind of legendary three-man teams that parachuted in behind enemy lines to fight with resistance groups against the Nazis and the Japanese. The OGs, they were the operational groups. They were the true forerunners of of the Special Forces, and my father served in OSS during World War II. He went behind enemy lines in China and fought with the Chinese nationalists against the Japanese. The society of which I serve as president is composed of veterans and their direct descendants. And the more I know about OSS, the more I'm convinced that it was probably one of the most remarkable organizations ever created by the U.S. government, principally because of the leadership of a legendary guy named General Bill Donovan, who won the Medal of Honor in World War I, and I think is the only person to have won our nation's 4 highest commendations. But he created this organization shortly after Pearl Harbor, and it's interesting because many of the symptoms that led, I think, to the intelligence failures after 9/11 were also evident after Pearl Harbor. We had some small fragmentary intelligence organizations, but they didn't really centralize the data, and we had that same problem after 9/11. Donovan recognized this, and so did Roosevelt, even though they came from completely opposite ends of the political spectrum. And with the urging of the British, Donovan created OSS and really created a wartime and worldwide intelligence network in the space of 3 years that went on to really shape our national security. And some of the really remarkable people who belong to OSS include Julia Child and Arthur Schlesinger Jr., Supreme Court Justice Arthur Goldberg, Sterling Hayden. I'm sure many of you remember him. He played the insane general in Dr. Strangelove, and the corrupt cop in Godfather. He was another member of OSS. He actually ran guns, I think, in the Adriatic to resistance groups. John Ford, the legendary film director. Jack Hemingway, Ernest Hemingway's son, was in OSS, and in his memoir he tells a story of parachuting in behind enemy lines and bringing with him a fly fishing rod. One of the most remarkable women who served in OSS, and there were a large amount of women who did serve in OSS, was a woman named Virginia Hall. She's the only woman to have earned the Distinguished Service Cross in World War II. The Germans called her the limping lady. She'd lost a leg in a horse riding accident, and they brought her in by boat across the English Channel, and she organized resistance groups behind enemy lines in France, and the Germans were hunting her down and were never able to catch her. There's a new book actually about her that just came out. It's called Wolves at the Door, and I recommend that you read it. And that's it. Thank you very much.
We now have as our anchor speaker Scott McGrew, who's going to talk a little bit about what these surveillance issues mean from the point of view of presenting them to the public. What does the public think about all this?
I don't think the public knows, and that's part of the problem. Good morning. I would consider myself to be kind of the ultimate middleman. If you are the people thinking about or creating the technology or litigating some of the arguments about privacy, then I am the person who takes those very complicated subjects and tries to present them to everyone else as they're trying to get ready in the morning to go off to school or to work, that sort of thing. And I try to do it in 30 seconds or less. And I want to show really good pictures while it's happening. I'll give you an example of that is Sony's Rootkit, which you may be familiar with. It was software on the Sony music CDs that would actually infect into the computer and broke a number of different agreements and laws. And to present that on television is very difficult because, first of all, you can't take a picture of a rootkit. So what we did was we found some Sony BMG artists, Destiny's Child, and we would run that while talking about the rootkit. And you can, you know what's happening at home. Oh, I love Destiny's Child. As opposed to listening to what it is we're trying to tell you about Sony's rootkit. Now, newspapers, Wired magazine, and law journals will do a much better job of presenting this material to the public, but I have a bigger reach than most of those things do. And television has been covering technology for quite some time now. I cover technology here locally for the NBC, and then I have a TV show that we run in New York and Chicago as well, and then I work for, we're just one big umbrella group. I work for MSNBC and CNBC as well. MSNBC and CNBC particularly are doing an awfully good job with this. MSNBC has done a lot of privacy issues that aren't scare tactics as we try to present some of these things to you. And the public seems somewhat,
they tell us they are concerned with their privacy. They tell us they're worried about identity theft. We don't know if they're worried about identity theft because we made them worried about identity theft, or they genuinely are. But then I will go to the mall and see the people, you know, they got the car in the middle of the mall, and there will be people filling out forms as fast as they can, and oftentimes that car's not even the prize, if you read the fine print. And these are the same people that are telling me they're concerned about their privacy. And I had the idea, nobody's ever gone for it yet, of setting up a booth in the mall. This would be a TV story, of course, in which we have given away T-shirts or something. Not NBC T-shirts, but some kind of T-shirts. And you'd fill out a simple form, your name and your address or something. And then after about a half an hour, we changed the form. Name, address, and last 3 jobs you worked. And then a half an hour later, we changed the form again, name, address, and the code to your burglar alarm. Or maybe, do you own a burglar alarm? Then half an hour, what's the code to your burglar alarm? And keep going and going and going and see how far we could get just giving somebody a T-shirt for something like this. And see just how much people are willing to give away. I think they are concerned about this, but as someone mentioned, not a majority, but a significant number of people are not terribly concerned about the presidential phone tapping scandal. And so we get very mixed messages. We have a problem on both ends. We have to present incredibly complicated torts and arguments and technology in a very short period of time to people that we're reasonable, because we're people too, we're the public too, we're reasonably sure they're worried about their privacy, and it's something they want to hear about and talk about, but we're not positive exactly how they feel about all of this. One of the great uses of quick reading chips is Fast Track, going over the Bay Bridge. Everybody loves Fast Track. And the moment you compare some of this to Fast Track, I think there is that reaction of, oh yeah, I love that. That's great. Well, yeah, but it'll be in your sweater. You lose. It's hard to explain where this could go wrong and how. And then, again, with television, how do I take a picture of it? Not only is it very small, but how do I take a picture of the concept of this could be a problem to you? People don't tend to care about something until it directly affects them. The number one question they want to know is, am I safe? Are my children safe? Literally the very first thing they want to know is the weather, which here is the same thing every day, all the time. But we push it hard because actually it does very much, when you think about it, relate to those first 2 questions. Am I safe? Are my children safe? Are we going to be well? And until something happens that we need an example, basically. We need somebody whose identity has been stolen before we can talk about stolen identities. And in the case of RFID, we need to wait until the technology develops and then somebody is violated in some way until we can then turn around and say something about it. I work closely with the Electronic Frontier Foundation with some of their. I find their ideas and their arguments interesting. I profess neutrality, of course, but I try to present a lot of their arguments because I think they're fascinating. But part of the problem, again, we have is that until it is a problem, we can't present it on television as being a problem. The one exception to that is bird flu. We like bird flu, and we'll talk about that all the time. There was a case in which RFID itself came up in the media, and that was recently a school in the East Bay wanted to put them on kids' name tags. And there would be this way of, I assume, of saying, well, 20 kids left the door for the playground and 20 kids came back, and if 20 kids did not come back, if 19 came back, a bell would ring or something. The school it caught the attention of the bloggers who were very angry about it. It is a flashpoint for many people. And the school got rid of it. And it's interesting that here's an example of the sound bites we ran. Well, I don't want people tracking my kids. But when you stop and think about it, I very much want somebody tracking my kids. This sounds great. I would very much like an alarm to go off if he does not come back from the playground after recess. They worried about stalking, which again, at least the example soundbites quoted stalking. Again, that'd be silly. Stalking somebody via RFID when you could just snatch them from the playground was not a legitimate example of how RFID could be a worrisome thing, but these were things that parents, who I'm one too, were justifiably worried about, but it seemed as if they were not quite, they hadn't quite grasped it yet. They were worried about people tracking their children in a situation in which they really should want people to track their children, and worried about other people tracking their children in a way that wasn't terribly realistic way of tracking their children, when there are so many, and we have that tendency, I think, to be afraid of gigantic, strange, convoluted plots, when really the truth is so much more simple. There are so many other easier ways to do people harm. When I talk up here, of course, I talk as an employee of General Electric and NBC and CNBC and MSNBC and all the different things we do. My thoughts, obviously, are my own, but let me say something about the media as well. It was Sonia that talked about surveillance by marketers. We are marketers. And those will be questions that we will need to address as this technology gets more and more common. Yes, there is a sandbox in the newsroom between a pure journalist and a salesperson and a manager and somebody involved in the technology of television, and those aren't supposed to cross, and they rarely do. There isn't pressure on journalists to do things one way or the other. But journalists work for a TV show that gets ratings, which are measured. We are marketing our knowledge and our neutrality and our ability to show you good pictures. We're marketing it to you, and then we're measuring it. We're measuring it through your TiVo box. We're measuring it through your cable box. We're measuring it voluntarily through your Nielsen box. We just recently went from diaries where you wrote down what it is you watched to an electronic, and I won't call it eavesdropping because you have to be a part of it. You press a certain number of buttons to say, hey, it's Dad sitting down and watching, or it's Dad and daughter who are watching now. But we measure that minute by minute now, electronically, and get those results the next day. That's not to say that we would abuse the information, but one of the things that when we talk about media or journalism, when we talk about bringing your issues, your arguments, your ideas and thoughts to the public, is we have a somewhat schizophrenic use of technology and surveillance and marketing, and that is we both need to talk about it in a neutral sense, but also there are pressures on us and the ability for us to do some of the very measuring that you're speaking of. Perhaps not RFID, although perhaps newspapers would do that with the bundles they drop off, that sort of thing. But we do something very similar with unique codes and measurement and that sort of thing as well, and I think we do a pretty good job of policing ourselves. Also, the information that we would use, I think some people would be uncomfortable that we know you watch Jerry Springer. But it's not something that we think would harm you. But then I think a lot of the companies that are marketing these RFIDs or who would be using them would think this is not information that would harm you. And where you go from there is actually up to you. Those are my thoughts.
Questions from all of you, but we also have first some questions and responses from members of the panel.
I have a comment for Scott. 50, partly cloudy, chance of rain, right? I mean,
I get mistaken for that guy all the time, and the nice thing is when you're in the Bay Area, you can make a pretty good prediction. It's going to be fog in the morning, burning off to partly sunny in the afternoon, and that works every day.
Do you think that the future? First of all, I absolutely love my TiVo. It's the greatest invention ever made. Is it the hope of the media to be able to individually tailor advertising to the people sitting in front of the television? Is that where you hope I mean, obviously you don't speak for everyone in the media.
No. And not only that, but advertisers themselves are independent from us in the sense that we, and this is a joke that is funny because it's really quite true, is you're told sometimes that the reason you have a newscast is to fill the space between the commercials. And that's what we do. We run commercials, and we run as many of them as we can, and then we try to fill it with some interesting stuff in between so that you'll sit down and watch them, the commercials. That sort of technology is not being developed at the network or even at the TV station level. That's being developed more in the TV technology area, et cetera. It's something we'd be happy, as long as advertisers pay us. We don't care how it's done. But yes, certainly that is something that is happening.
Charles and Scott, both really, really great, interesting things to think about. I guess, Scott, I had a couple of thoughts. One of the things that I really liked about sort of the things that you were saying with respect to Sony Rootkit, and this is something that I think, in particular, the role of the media and bloggers have a tremendous power in, is getting people sort of informed about different decisions, and then creating a situation where actually the company decides to relent, right? And the company decides to make certain choices in response to an outcry that happens. And I think that kind of private under-enforcement is something that I think is really, a very sort of underexplored avenue for change. Like, I think in many ways we, particularly because so many of us are lawyers and individuals who are interested in sort of getting in the courtroom, I think that this is another way in which we can create a more dialogic relationship between companies and their consumers, and you guys play a really key role in that. I guess one of the things that I was curious about is whether you see, in terms of the sort of outcry that you see when you inform people, whether you can draw upon any differences with respect to public reaction. Are they more upset about marketing and privacy issues, or do they tend to be more upset about privacy issues raised with respect to government surveillance? Like, do you see a difference between private and public?
No, I think they're more upset with marketing. I think 9/11 had something to do with that, that if you had asked that a few years ago, the answer would be different. Also, and I touched on this, they're somewhat schizophrenic about being upset by marketing. They say they are, and then they don't always, and I say they, it's all of us in this room, for goodness sakes, as if it's the great unwashed masses. But so I'm as guilty as everyone else. They say they're worried about it, but they don't behave like they're worried about it.
Well, I think in part that may result from them not being able to tangibly know about the surveillance as it's going on. I mean, in my job, if I know I'm doing my job well, if the person, for instance, that I have under surveillance doesn't know I'm doing it, but if they find out,
they'll be outraged.
They're going to be outraged, right? And I think the same thing applies with this.
Yes, I think that's fair enough.
Nobody knows if they're being wiretapped.
I am surprised that TiVo, at the end of the Super Bowl every year, will have a news release, and they'll even give us a clip of, the most watched or most rewound commercial was Britney Spears or whatever it is. I just keep thinking, TiVo, shut up. If you can do that and you can't, don't talk about it. They can market that information to the advertiser, but don't tell everybody. It just seems like common sense. Don't tell everybody you can do that.
This comment probably applies more to the next panel, but I wanted to pass it along. I was at a party recently, and I started talking with someone about what he did, and he said he was a pollster. I told him what I did, and we started chatting. There's an outfit in Arkansas called Axiom. Maybe a lot of you have heard about it. They collect information about all of us. And it's written about in this book, which I'd recommend to all of you, called No Place to Hide by Robert O'Hara. It's a great book. He said he takes his voter registration files and cross-references them with the Axiom files, and they have up to 2,000 variables per person, which is just staggering. I mean, what wouldn't you know about somebody after that? Almost nothing.
Nicole. Scott had mentioned the school that had RFID badges, and I think he was actually referring to the school in Sutter, California, which is an hour north of Sacramento.
Yes, I said East Bay, over that direction.
And I just wanted to bring that up because I do have some personal knowledge about that, as well as Lee Tien back there. Lee and I spent many hours up in Sutter working on this issue, and it was actually an issue where the parents Their children came home, 7th and 8th graders, with badges. Parents never knew that RFID badges were going to be given to the students. And when they went to the school and were concerned about what the technology was, what the privacy and security implications might be, the school said, if your kids don't wear it, we'll discipline them. No reaction to any of the privacy or security implications of RFID. And it was after the kids were threatened to be disciplined that these parents who are conservative, law and order, former military, living in a rural community, called the ACLU and EFF. And that's when we went up there to talk to them about, you do have a basis. You're not going crazy. There are privacy and security implications. And it was because of the national and international attention that that story had. The fact that the press, here was an example. Here was a situation where the first public school in the nation, kids were being forced to carry RFID badges, and it was an issue of fundamental privacy to these parents. This was a rural community where their cattle had RFID tags. And they clearly, whether the information could be read by people in the school or out in the community, it was a fundamental issue to them. And also they understood that this was an issue of the proliferation of the technology and people being forced to carry RFID tags without privacy and security protections. And so I just wanted to say that, they understood this is about their school, other schools, about it being in driver's licenses, about it being in U.S. passports. And they understood that this was an issue of the proliferating and that it takes individuals like that who live in small towns at definite risk to themselves and to their kids playing on the football team who have to deal with teachers that, don't like them so much anymore. It takes individuals like that to stand up, and without them, and without the national and international press, the RFID bill here in California would not exist. RFID bills in New Hampshire would not exist, in Illinois would not exist. And so, since you had mentioned it, I thought I would give a little background since it's an issue very close to my heart. So
I try to gloss over in 30 seconds or less.
We have a question, Bill Fenwick.
As it relates to the RFID and the incident that we were just hearing about, I wonder what would have happened if the school had approached this a little differently. If the school had sent home the information that said, we are considering, here's a problem we've got. Your children go out of the school and we cannot have somebody following them around to make sure that they are being paid for and that they're still there and all that. So what we've come up with is a plan that if we get them to wear an RFID badge, when they leave, it will be noted, and if they don't come back, we'll be given that information and we can act. And we can act not 2 days from when they disappeared, but within an hour of when they disappeared. I wonder if that result wouldn't have been very different, because it was a community that knew what RFID was as a result of their agricultural use of it. I just wonder if that's not a bigger problem, and it goes across the board on privacy. If you let people know why something is being done, I think you will defang much of the panic and the angry reaction. And I wonder if you agree, or do you think that that's just giving warnings going to get them out earlier rather than later when they find out about it?
Well, certainly the stars aligned in Sutter that they did everything wrong that they possibly could have. But I think that in the issue of RFID tags, the fact that there were no privacy or security protections in that information as well sort of doesn't fix the problem. Where we see in the U.S. passports, initially RFID tags being put in the passports with no privacy or security protections. Now they're being put in the U.S. passports, but with protections to try try and keep that information safe. So I think it's not necessarily and the way that the bill in California is framed as well, is not no RFID anywhere anyhow. If you're going to use a technology that is built to be able to have surreptitious access to the information, then you need to build in the kinds of privacy and security protections to ensure that the information is only being used for what it's intended to be used for and not being read by others. So.
And I'm reminded of the ad that Chase Bank has put together for their PayPass product. I mean, the reason this may end up becoming successful is because they have promoted it as convenient. And to go back to Scott's point, perhaps when consumers are presented with the choice of, do I care about my private information being tracked, and oh boy, I don't actually have to sign the charge slip, maybe that makes the difference, and they say sure.
And I think from a marketing perspective, PayPass helps a lot. When you say we're going to give your kids RFID tags, as opposed to Safe Stars or something like that, it certainly makes a difference as well. Is how you present it, and I wonder when the first company is going to pitch me an idea to cover in which I don't recognize. These are RFID tags because they've given it a clever name. In fact, I would recommend to that industry they rename them, at some point.
What was that name? I'm going to copyright it.
Safe Star?
Safe Star.
I like that.
The gentleman in the back, I'm sorry, I don't have your name.
Yeah, Rob Atkinson. I got two comments. One is I carry probably 5 RFID devices on me. Most of you probably do, a cell phone and a wireless key access for your office. But in relation to Scott's comment, one of them that I carry is I live in Washington. I have a Metro, little contactless Metro card. And it turns out that, which is readable by about 3 inches, by the way, from the device. If you ever try to go through Metro and hold it a foot above it, it won't read it. But one of the things they do, you can get this card and you pay $5 for it, and you store up that, $200 or $300 worth of Metro fares if you want to on it. But if you lose the card, you've lost all that money. So when they give you an option to say, give us your name and address, and we'll attach it to the card in our electronic database. And then if you lose the card, we'll refund your money. And it turns out that if they do this, which I've done, now the Metro knows everywhere I go. They know every stop I go and get on and get off, and they know the time. Turns out something like 90% of people go ahead and do that. They submit their information because A, they value the money more than they value their own personal information, and B, Metro is never going to share the information. So I think in a lot of cases, this is vastly overblown. I guess the other point I wanted to make to Lars, I think your paper is sort of missing, I think, a key point, which is the distinguishing factor between barcodes and RFID. I can go and buy this bottle of water in a store, and it can be attached to my PII if I buy it with a credit card. The store knows exactly who I am. They know that I bought this, and it's in their database, and they've been doing this now for 25 years. Now, I could buy the same bottle with an RFID product on it. If I pay cash, there's no PII attached to it. There's no database. So I think the debate has to move beyond the technology. The technology to me is irrelevant to the debate, and it's just another form of collecting that information. And it needs to be about what do we think about the fact that marketers or companies are able to already collect information about what we buy if we give them things like a credit card or a check.
I think you're absolutely right. I think that the problem isn't the collection, it's the cross-referencing, right? Being taking one piece of information and cross-referencing it with another. The issue that I'm looking at specifically with respect to RFID, and it isn't necessarily limited to just RFID, any technology that includes embedded tracking abilities. So if you buy that bottle of water, I seriously doubt this will happen, but if for some reason Arrowhead decides that they want to know where you go with that bottle of water, when you buy it, it's cross-referenced to you individually because you paid for it with a credit card, they know who you are. If it can now track you throughout the world and you then come back and they read the tag, they not only know that you bought it, but where you went with it. And it's the question I'm looking at is to the extent that the tags are able to do additional tracking, have additional tracking capabilities. who has the right to control that information? But I think you're absolutely right. The issue here is cross-referencing the data. The fact that you bought a bottle of water, really, who cares? But over time, with your customer loyalty card, what do you buy, and the building up of this enormous database, that, of course, also has dramatic implications, and it's not tied just to RFID. It's any way that information is gathered and tracked that is the issue.
And that leads directly to our next topic, which is going to be digital dossiers. We have about a 10-minute break. We'll be back at 11 o'clock promptly. If you are here getting MCLE credit, I've been asked to remind you to give your evaluation forms over to the registration desk in order to get your MCLE credit. So we'll see you back here at 11 o'clock.
Before you all break, I just want to thank all of our panelists. Hi, I'm Elizabeth Morris, I'm editor-in-chief for the Journal. We've been really happy with this first panel, and we're looking forward to the rest of the day. We have a little thank you gift for our panelists and our moderator.